Mamu na akwaba at the bank assertive native when Chebia and a US abrochima tried to come Ghana Hasintino. You multiple visa entry are your one privileges no. Mutum I am a single visa entry all because of AS and Simbia a ura. Okugbetu Ablakwah Ekwabontin Skokai a US senator on mutum in a single entry. And Chebia no Samson and multiple entry all because of say and Ghana and US a memorandum of understanding. It has high-end criminals, blacks, and as deportees are US abrochima deported to me. I don't know Ghana. Me must see 84 years and Ketua. And I truly no. At the sample for Eba Ghana, I be send a beefy Ivory Coast, beefy Togo, beefy ha. That's not Chibia na Ghana. My society testing sana high-end criminals and Kasa beefy Colombia, a beefy Nepal, beefy ha, beefy na chese. I can't come home about Ghana. Me must see. Military training can be our baby. Now, since we better abontinate for the whole lot of confusion at the buyer, I for years and Ketua. Now, said there high end criminals for some in Ghana, by some deport some other main country or movie at the buyer. And let's see for much that anti-as on the assembly at the court and come high on some represent to Oliver Baker Vomawo, Democracy Hub now Odano. Now, fortunately, no, for the Attorney General Minister of Justice, Dominic Ayine versus Honorable Okugbetu Ablakwah na case no more versus Oliver Baker Vomawo etifume lusu ne brada anya asem ketwa. Ekune kutin ko boni sensem course or hono medam nyina.
Temporarily detained deportees of West African nationals from US Immigration and Customs Enforcement facilities. Ya kire say nipa hodwa efri amama ya etwa Ghana ho ahia ye no omo ebobra West African nations ya for one or two reasons omakodi boni wa America ne ache omo agum no instead say nke do mbekọ omo countries no Ghana yakosa memorandum of understanding say ye beji omo a na nko for say edi anadwuma na assemble ni ye ho na eti say some 42 individuals have been repatriated in 3 separate batches into this country as part of this memorandum of understanding. Majority of them are West African nationals. Said na MOU no eka. A bit from Mexico, a bit from Panama, a bit from Colombia, a bit from hardened criminals. Ya omo ewo detention centers ewo US. Na Ghana for me say Okugbetu Ablakwah beka kire ye say the arrangement forms part of a broader negotiations with the US to lift visa sanctions. Yeah, arrangement no. A memorandum of understanding in Ghana reached with the United States to receive and temporarily detain deported West African nationals from US Immigration and Customs Enforcement facilities. The then after the be free Mexico, be free Panama, be free Colombia. No money ya to mo dia be Ghana. Na even no kro free West African nations say Nigeria ne Cameroon ne Togo ne ade. E die ntine nipa na kwa America bruchima mu akodi bone. Na order J, ne pese deport no a, yansa mfa ne nkɔ ne mamu ne ya ka ro se yaji wo. Nti we de ye ntiase. De te ya ne say 42 individuals ya repatriate wo in 3 separate batches no. Afa de Ghana ban detain wo under armed military custody. Ewo bondase military training camp say. Yeba be deport wo. And these 42 individuals, lawyers no se there be. Omo be file charges de tia Ghana by because nyoma ekoso no mani nye ho. And omo Oliver Baker Vomawo ya represent civil society group from Democracy Hub. And Oliver Baker Vomawo file writ was Supreme Court. The kind challenge the unconstitutionality of the memorandum of understanding which them say ankom rashe bedwam. Now then a memorandum of understanding between two countries, they said Ghana and the US. Ya beje to bra rashe bedwa anywhere. Na ya je foreign nationals. Ya be hardened criminals e wo man yi mu. Say they know Samuel Okugbetu Ablakwah. Enti enioma 9 and what they call down Supreme Court. 1. Says Supreme Court. Entry Attorney General. And after the Foreign Affairs Ministry. More ehunu say. Some memorandum of understanding. 1. It is unconstitutional. 2. It lacks legal grounds. Afe de toso mienu, it is in violation of international law. De toso miensa, nipa duanan mienu no a omo ya foreign nationals. Ya omo ba ya Ghana ban so detain omo bundase no. It is an abuse of human rights and afe de toso 9. There is a complicity in chain refoulement. And no interest yen say by participating in the transfer of individuals who may face prosecution elsewhere, Ghana is allegedly facilitating a grave breach of binding principles of international law from which no state may derogate. Tisanyoma Anna Oliver Baker Vomawo on the 22nd of October 2025 at the Supreme Court now seeking for interlocutory injunction to halt the implementation of the agreement pending the final determination of the case. Court na brasa ene Supreme Court ruling. Now by a unanimous decision, the Supreme Court, presided over by the learned Justice Gabriel Scott Palman, in the case of Democracy Hub versus the Attorney General and the Foreign Affairs Ministry, has upheld the motion for discoveries filed by Democracy Hub, seeking disclosures from the government of Ghana on the agreement between it and the United States of America for deportees of West African origin into Ghana. The Supreme Court held in its ruling that the disclosure of that said document should be made public at the office of the Attorney General, where the plaintiff's counsel, the learned Oliver Baker Vomawo, shall go and inspect the agreement. And the Supreme Court say, sa agreement kronwa, eye memorandum of understanding. Ghana ni America ban kwasensan ya mrahye bedwa anhuru. Ghana fo ya anhuru. Na your Foreign Affairs Minister Samuel Okugbetu Ablakwah beka kire ye say, just a verbal agreement inti na ehia parliamentary approval no. Supreme Court say, we entumi nya verbal agreement. Enu nti animu ya sa agreement no. Attorney General nkwaje. No fa meto no office. Na Oliver Baker Vomawo onu na lead Democracy Hub for onko no hwe sa agreement no na onkinka emuhunu enyo me was agreement ni mu because your lawyer ni all represented these four repatriated nationals. The court further stated that if the plaintiff's counsel, after inspecting the document, is minded to file a supplementary statement of case in support of his injunction application, the applicant civil society group has the liberty to do so. The ruling of the court comes after a series of adjournments in the matter for the filing of processes by the Attorney General against the motion of the civil society organization against the court deems the case as a matter of public interest. The Supreme Court panel, which dispatched the orders of the court in the ruling on the application for discoveries, was constituted by Justice Gabriel Palman, Justice Ernest Gau, Justice Ejay Frimpong, Justice Jamefe, Justice Hafiz Sata, Amaniboba. Enti Supreme Court unanimously chirimwa such an agreement. There was hunu di womb. The Attorney General, Dr. Dominic Akutinga Ayine, the Foreign Affairs Minister, the Honorable Samuel Okugbetu Ablakwah, and to many America buying contrase enye memorandum of understanding, and ko jenko for mo face persecution wa America. And for mo dina oman yimu si assign memorandum of understanding, bra yenim ho hwe. And ko chenko for ade hye for mo ko gu bundase. Enunti the office of the Attorney General making sure say some letter chrono memorandum of understanding chrono America bind to me say and confirm this year face various charges of crimes. Ya omo ya under detention. Ye repatriate omo for omo na Ghana no. On for some memorandum of understanding no. On fan to the office of the Attorney General. Na Oliver Baker Vomawo as a lawyer representing the 42 enko no nko kenkan no hu na de kure wo sama mena no ho na sande ni na wa kenkan wi a enioma bi wo mu po na sentiase anya dwuma owo kwan se osan file further supplementary affidavit to support the motions in the case because that case